This habeas corpus ruling set a precedent by extending certain human-like protections to animals based on their cognitive capacities.
Our next speaker is Priscila Gulič Pirnat, founder of the Citizens Initiative for the Improvement of Legal Protection of Animals. She is a leading voice in shaping stronger animal protection laws in Slovenia. Priscila is also active internationally as an expert in animal law and ethics while pursuing her PhD at the University of Ljubljana. In her today's talk, Priscila will explore how Slovenian legislation is shifting from welfare-based approaches toward abolitionist reforms and what this means for the future of animal rights. Please welcome Priscila.
Thank you very much. It's my first time here, and I'm very happy. Hopefully not the last time. Thank you also for the presentation. We don't have much time, so I will start with the introduction. In this presentation, I want to explore Slovenia's ongoing shift from traditional welfarist approach focused mainly on minimizing suffering toward measures that are more abolitionist in nature, where the goal is to end certain uses of animals altogether. My focus will be twofold on legal theory, the philosophical and conceptual frameworks that can justify stronger protections for animals, and second, on legislative practice, how these ideas are or could be implemented in law and policy. At the heart of this lies one central question: how can civil society, and by civil society I mean activists, NGOs, and concerned citizens, help pave the way toward animal rights? This is not just a legal or political challenge, but I think it's mostly a cultural shift, one that requires rethinking how we define rights, justice, and community. By looking at Slovenia example, I hope to show both the opportunities and the obstacles in this transformation, and how theory and practice must work together if we are to achieve real changes. So, to understand animal welfare law, we need to start with its ethical foundation, the 5 freedoms, developed in 60s, 70s, and these freedoms represent internationally recognized minimum welfare standards, or should be. They guarantee animals freedom from hunger and thirst, discomfort, pain, injury, or diseases, fear and distress, and the ability to express normal behavior. These freedoms have guided welfare legislation worldwide and serve as ethical benchmarks. However, it is important to note that these freedoms do not establish legal rights per se. They set minimum standards to prevent cruelty, but they do not confer any substantive rights or subjectivity on animals. This limitation has prompted many scholars and activists to seek new approaches beyond traditional welfare. New welfarism is a term often associated with Gary Francione's critique, but also developed by thinkers like Gardner with his animal protection concept. This approach still works within the existing systems, but it views welfare reforms step toward eventual abolition. The idea is that each improvement brings society closer to a point where animal exploitation is no longer acceptable. Finally, we reach abolitionism, championed most prominently by Francione himself, As you know, abolitionists reject the use of animals altogether, whether for food, clothing, entertainment, or research. And understanding this spectrum is essential because it reveals that even within animal ethics, there are different visions for what justice for animals truly means. New welfarists believe that many animals only have an interest in not suffering. Therefore, owning them, keeping them, and using an animal is not necessarily problematic. They do not believe that animals must be given the right not to be owned for this exploitation to stop. But they also believe that not all human interests are morally more important than those of animals. They argue that even the painless use and killing of animals for certain purposes must be limited by granting animals' rights when possible. Taylor described the new welfare position as hybrid approach. It adopts the means of classic welfarism while still endorsing abolitionism's goal. The Slovenian Animal Protection Act includes anti-cruelty protection and well-being of animals. Over the last decade, or better, last 15 years, there has been a very strong civil initiative to improve the legal protection of animals in Slovenia, which I founded, and together with other NGOs has been quite successful in proposing improvements in animal welfare and bans on certain animal practices. The latter includes a complete ban on the use of all animals for their fur, skin, and or feathers, and the use of all animals in circuses, which could be seen as an abolitionist outcome. One could say that the Slovenian Animal Protection Act is in some ways a hybrid model based on classic welfarism, but containing some provisions that abolish the use of all animals. New welfarism states, among other things, that animals have some simple rights. For example, the right not to be treated cruelly or the right not to suffer unnecessarily. And second, that human rights are not always more important than animal rights, especially when certain practices are not necessary, for example, circuses, or there are alternatives to them. For example, instead of fur, feathers, we use alternative materials. Slovenian civil law places non-human animals in the rank of objects and subjects them to the regime that applies to objects, but at the same time, it also provides them with a special regime of protection due to their special abilities, for example, sentience. In the Slovenian legal systems, animals are also recognized as living sentient beings, which is guaranteed by the Animal Protection Act, Article 1, and as specially protected objects in the Property Code, Article 15a, where it is explicitly stated, animals are not things, but sentient living beings. Their protection is regulated by special laws. And the provision continues, the provision of this law governing movable property shall apply to them unless the law provides otherwise. New legal provisions that incorporate a new moral category, namely the sentience of animals, are of course welcomed and indicate a change in society's perception of non-human animals as beings with inherent value, albeit only on a symbolic level for the time being. It could be argued that the current legal status of animals as objects is in a gray area, as non-human animals are treated as things in most legislations as non-things. Some national legislations explicitly state that animals are not things, but paradoxically treat them as things. And as sentient beings treated again as things in the Treaty on the Functioning of the EU, for example. But it also seems that moving away from the perception of animals as mere things is one of the main trends in the development of animal law in Europe and also in Latin America. As we mentioned before, at the level of the EU and as well as at individual EU member states, the sentience of animals was recognized, but not their interests. Welfare laws have proven to be ineffective or not effective enough in protecting the interests of animals, so improvements or new approaches seem to be necessary. If we assume that animals are living sentient beings with interests, can they also bear certain rights? Slovenia has made important legislative strides in recent decades, notably the ban on fur farming and use of animals in circuses reflects growing societal concerns with animal commodification and exploitation. Additionally, the 2025 decision to abolish battery hen farming by 2029 signals a commitment to phasing out particularly cruel industrial practices. These reforms are largely driven by civil society activism and public pressure. The ban on battery farming is thanks to Animal Enterprise Transparency Project, which is also one of the few NGOs in Slovenia working in the field of farmed animals, and they are doing really an excellent work. These reforms thus reflect a hybrid legal model incorporating welfare improvements and abolitionist tendencies, but not full recognition of animal rights or legal subjectivity. Building on the question of whether animals in Slovenia have rights, let's look at possible future paths from reform to abolition. First, the status quo. Animals are legally considered property. Most protections are indirect, like preventing unnecessary suffering. Socially, animals are seen primarily for their instrumental value, and the legal strategy focuses on minimal welfare standards. Next, we have new welfarism. Here, animals remain property, but their use is increasingly restricted. They receive partial and conditional moral rights, such as reduced pain or improved living conditions. Socially, some animals begin to be seen as moral subjects in certain contexts, and the legal strategy emphasizes gradual reforms framed as moral progress toward ending exploitation. Then could come partial legal subjectivity. Certain cognitively advanced species like great apes, whales, or elephants could be granted legal subjectivity or similar protections. Their rights would become unconditional in key areas, for example, the right to life or freedom from captivity. Social perception shifts with growing consensus that some uses of animals are morally unacceptable. And legal precedent can help extend protections to other species. Finally, abolition. would represent the full vision. All sentient animals are recognized as subject of rights. They would enjoy rights, including life, bodily integrity, and the ability to perform natural behaviors. Socially, animal exploitation is seen as morally and legally unacceptable, on par with human exploitation, and the law exists primarily to protect and enforce these rights, not merely to limit the harm. But is all this even achievable? To unpack this further, we can use some legal theory. And as you can see on the table, we have traditional view from Stephen Weiss, very known in his work at the Non-Human Rights Project. And on the other side, we have an alternative view from a colleague, Eva Bernat-Kempers. So if we just look a bit the traditional, the orthodox view from Stephen Weiss, we can see that on level 0, we have animals as property with no rights, and then in order to achieve, for animals to achieve some positive law rights, rights of action, or even legal standing, they should have a legal personhood. So the base for everything is legal personhood. On the other side, as mentioned, we have the alternative view, which I find very, very interesting. And on the base, we have animals as property. This is a starting point. And at level 1, simple rights. These are the basic legal duties to which animals are entitled under applicable law, such as the duty not to cause them unnecessary suffering. Even though such rights are rarely formulated as real rights by courts or legislators, they imply that animals are the intended beneficiaries of the legal duties. Here, Bernat-Kempers draws on the work of Saskia Stucki, who clarifies that these duties, although limited and often weak, could represent the first legal recognition of animals as more than mere objects, because duties and rights are correlates. At the level 2, fundamental rights are introduced. Here, legal protection becomes more robust. Rights protect essential interests, such as the right not to be killed or exploited for certain purposes, and have greater normative weight. Examples of these are, for example, the ban on fur farming, or the legal ban on the killing of certain wild animal species, such as wolves, under EU conservation law. Although these rights are still not formulated in terms of legal personhood, they are more similar to the rights that humans have. And she notes that while such rights are rare, they are growing in number and could eventually be enshrined in international conventions or constitutional provisions. For example, Europe is almost fur-free in this meaning. On level 3, we have incidents of legal personhood, and here this model departs most clearly from the traditional binary, objects, subjects, and here we draw on Visa Kurki's bundle theory, and she argues that legal personhood is not an all or nothing status, but a collection of attributes or incidents such as the ability to sue, to be owed a duty, or to own a property. And that can be granted in varying degrees. Animals can acquire these incidents without being fully recognized as legal persons. She points to developments also in France and Belgium, where animal protection organizations are allowed to represent animals in court and receive compensation on their behalf. Although animals are still technically property, their interests are recognized and enforced through procedural innovations. In other words, animals can simultaneously be property and carry important legal incidents normally associated with persons. And the final level, independent legal status or legal personhood, represents the stage at which animals could be fully recognized as legal entities, either through a traditional personhood framework or through alternative models. So, gradual path to legal subjectivity of animals. This is, of course, just an attempt. This gradualist model is only, as I said, an attempt, and particularly suited to civil law systems where judges tend to be reluctant to act, and the legislator plays a central role. Here we have an alternative to the personhood first strategy that is more pragmatic and flexible and takes into account the heterogeneity of animal lives and legal contexts. Moreover, this approach avoids the problematic emphasis on cognitive similarity to humans that prevails in traditional view. Rather than assigning animals a fixed status, the table is intended to illustrate the potential for legal mobility, how animals might rise through the stages of legal recognition based on evolving ethical norms, scientific knowledge, and policy decisions. The model allows for different routes to recognition. A wolf may ascend through conservation law, level 2. Okay, now it's not the case because it's not good for wolves in Europe right now. A dog through family law, level 3, and a chimpanzee through litigation, level 4. This flexibility allows the framework to take into account the diversity of animal life and human-animal relationship while keeping the legal instruments open and adaptable. Animals may initially receive some simple welfare as passive beneficiaries, level 1, stage 1. But as public opinion, legislative ambition, or scientific recognition of sentience increases, they may gain stronger rights, stage 2, and procedural visibility, stage 3, or eventually be seen as full legal subjects, stage 4. This transformative potential is central to Bernard Kemper's approach. Legal personhood is not the starting point, it is a possible outcome of cumulative moral and legal progress. Another path, animals and in the constitutional law, debates about the ways in which human decisions affect the lives of animals are deeply political issues and are increasingly perceived as such. Constitutional theories seem to have no place for animals, no way to explain why their lives and experiences matter to the law. According to Jessica Eisen, animals are constitutional subjects with an undeniable stake in the constitutional order, with interests and priorities that should therefore be part of constitutional politics, but they cannot, of course, themselves participate in elections or litigate. At the same time, harm to animals is institutionalized, legalized, routinized, and this makes them extremely vulnerable. Eisen argues and goes on to say that the law is inevitably implicated in these harms. Constitutional animal welfare is necessary and legitimate because animals routinely suffer extreme harms that are supported by the law and can be and should be addressed by the law. We have here a concrete problem of justice with constitutional dimensions. Oliver Lebeau argues that the constitutional question is of fundamental importance. That's why individuals, organizations, and companies that use animals try that hard to write their view of the world and animals into the Constitution. For example, hunters would not have a constitutional right to fish and hunt in more than 20 US states. Lebeau proposes two ways of enshrining animal protection in the Constitution. The first way is through interpretation. It is possible to recognize a constitutional obligation to protect animals based on the right to the environment. The second way would be to revise Constitution by adding a specific provision on animal welfare. He makes three proposals. The radical one, it is forbidden to kill animals or harm their welfare. An intermediate proposal, it's forbidden to kill animals or harm their welfare unless this is expressly provided for by law. And a more, let's say, in his view, realistic proposal, as animals are living and sentient beings, their lives and welfare must be respected. We have some countries also in Europe that put some provisions regarding animals into the Constitution. Recognizing animal welfare at a constitutional level is relatively a new phenomenon in our history and is likely to expand as more consideration is given to animals. An important example here is Finland, where the Finnish Animal Rights Lawyers Society has made a proposal to strengthen the legal status of animals, although this is not explicitly mentioned, by including animals in the Finnish constitution, by protecting certain fundamental rights of animals, and thereby providing instruments for balancing the interests of humans and animals. The proposal extends to all sentient beings with the precautionary principle aiming to address the problem that the sentience of certain species is uncertain, and scientific views on this are constantly evolving. They do not exclude the possibility that an animal can be property and still have the rights protected. The proposal also argues that the systematic killing, extinction of lives, and destruction of habitats should be justified on the principle of necessity. The Finnish Animal Rights Lawyers Society has collected more than 50 100,000 signatures, and the proposal was or is still debated in the Finnish parliament. Given the procedural nature of constitutional reforms, any substantive change is unlikely before 2027. In 2008, Ecuador's constitution has recognized the rights of nature, a groundbreaking legal framework that grants nature the status of a rights-bearing entity. The provision has been invoked in some legal cases to protect ecosystems such as rivers, forests, wetlands. And one landmark case is the Los Cedros Cloud Forest ruling from 2021, where the Constitutional Court halted mining operations, affirming that the forest's right to exist and regenerate outweighed economic interests. This case demonstrates how constitutionalized rights of nature can serve as a tool to protect entire ecosystems rather than just individual species. New Zealand, 2014, the Te Urevera Act transformed the legal status of the Te Urevera forest, granting it personhood and making it a indivisible legal entity. The act reflects the Maori worldview, which considers land and rivers as ancestors. A unique co-governance model emerged where the Maori and New Zealand government jointly manage the forest. Revenue from ecotourism supports conservation efforts, showing the legal rights for nature can align ecological protection with economic sustainability. And this is good, or at least not worse, also for animals inside the forest too. At least I think so. In Argentina, Sandra the orangutan case, 2014, marked a historic moment in animal law. An Argentinian court recognized Sandra, an orangutan held in Buenos Aires Zoo, as a non-human person with the right to liberty. This habeas corpus ruling set a precedent by extending certain human-like protections to animals based on their cognitive capacities. While Sandra was transferred to a sanctuary, the case highlights the selective nature of personhood-based approaches, as millions of animals in zoos and labs remain without similar recognition. But maybe, just maybe, it signals the beginning of a more inclusive legal paradigm. Also, in the Indian Supreme Court declared dolphins to be non-human persons and banned their use in captive shows. And then also an act, regional act from Balearic Islands in Spain, legal personhood for great apes. Also Spain, Mar Menor Lagoon, legal gain legal subjectivity, and so on, so on. There are cases. So for the Finnish, the role of civil society, when we talk about animal rights within current animal welfare paradigm, our language matters, and we already listened to this topic at this conference, also about the nouns and so on. For too long, public discussions have been dominated by a vocabulary of prohibitions, bans, restrictions, limitations, or this negative. These, of course, are all very important achievements. They frame the animal as an object of regulation, not as a subject with moral standing. And by transforming bans into statements of rights, we are shifting the narrative. Instead of saying we ban fur farming in Slovenia, we can say and write on all social medias, animals have the right not to be used in fur farms. Or, for example, animals have the right not to be killed in Slovenian shelters. Animals have the right not to be used in circuses in Slovenia. It's completely different narrative as we banned circuses in Slovenia. Well, that's very nice, but there are no animals in this statement. So I think it's very important that we start writing, talking, and publishing all these achievements in a different way, because this is more than a semantic change. It's a recognition that animals are not merely the beneficiaries of human mercy, but holders of moral and potentially legal rights, even as property. And adopting animal rights-based language shapes public perception, legal scholarship, and policy making. It aligns our discourse with the broader human rights tradition, where the focus is not on what is prohibited to others, but on what is owed to the individual. This shift also matters for the future. Rights language lays the groundwork for eventual legal recognition. It asserts that these protections are not just policy choices that can be repealed at will, but fundamental entitlements rooted in justice. By speaking of rights now, we plant seeds for a society in which animals are recognized as subject or object of rights by the law. And the conclusion, Slovenian animal protection law is evolving from a welfare-centered approach toward a hybrid model, incorporating abolitionist ideas and stronger protections. While animals are recognized as sentient beings, their ambiguous legal status as objects sui generis limits the scope of their rights. Comparative examples from Latin America, India, and Finland demonstrate that constitutional recognition of animal rights is possible and may inspire future reforms in Slovenia and Europe. Civil society plays a crucial role in this transformation, not only through advocacy, but also through the words we choose. The language we use shapes the law we will one day have. By speaking in terms of rights now, even when those rights are not yet legally recognized, we drive the cultural and legal shift toward justice for all animals. Thank you very much.
Does it work? Yeah. Thank you very much for the talk. Officially, it's now time for dinner, but for anyone who is willing to sacrifice a little bit of the dinner time, we have time for questions. So, question to the audience. Who has questions?
Yeah, thank you for this presentation. We were both at the Rijeka conference where they showed these rights for the rivers and the lagoon. And what disturbed me there was that in questioning what that actually all means, it turned out that even if the river has a right, you can still go fishing there, which is really weird because you would have thought that the very basic of being a right holder is that nobody can use you to their advantage, which is not an advantage for you. So it seems to me that Ecuador and maybe even Spain with this lagoon have a different concept to rights as I understand it, or is maybe usual Central European tradition. What do you think?
Thank you for the question. Yes, I remember the conference in Rijeka, and I would say that this is all very, very, very new. All these legal entities, legal personhoods, legal subjectivity for, I don't know, for forests, for rivers, for lagoons. Also recently, I don't know what happened, but for example in Paris, they are starting, you know, to make public pressure on River Seine to be and to have a legal personhood. So I think that some restrictions are, of course, if there is a legal entity defined by the law. Restrictions, I don't know which kind of, it depends on the entity, but in general, I think it's really, it's this kind of thinking where to put animals in, or to give them some kind of legal rights or as objects or subjects, or to give them not the rights, but in the meaning, in the view of environmental law. So I'm not sure how is for individual animal in that river when a person is fishing, but I'm sure that at least there are some restrictions about what people can or cannot do inside an area that is protected by the law.
Okay, thank you. I'm going to be brief. I just want to make a small remark because I need to relieve someone at the reception. I'm here in the dark. Yeah. Okay. The thing is that every time a state official speaks about rights, when they're going to give you rights, yeah, I'm maybe a bit paranoid, but I know that on the back of their mind they already have duties as well. So I think I want to warn that when the animals get rights, yeah, they will also have duties. And one of the things that they're trying to imply now is brain chips for animals, so that you can communicate through speech with them. The next step, I already know is going to be, okay, but if we can communicate with you like a human being, yeah, then you also have the duties of a human being. And if you kill someone, then we will kill you. Then we will just put you down, or we will put you in prison, or you have to work because otherwise you don't get food. Stuff like that is something I would like to warn about. Yeah.
Yeah, thank you very much. It is, of course, a very tough problem because of the heterogeneity of the animals. But for me, it's I really feel good inside when I see that society's perception is changing, and that there are young legal theorists that are doing really a great job in advancing animal rights and animal law. So I'm optimistic.
We have another question back there.
Thank you.
What is the difference between subjective law, like subjective rights, like fundamental rights, and objective rights, like welfare law? Who is prosecutable by some entity? Is the only difference that you can prosecute it at the court, or is there some other difference?
I mean, well, to put it simple, it's very different if you are an object inside the law, or if you are a subject inside the law. So an object is just an object. It doesn't have any legal standing, any procedural rights, or positive law rights, and so on. So you are a property, you are owned, you are a thing, you are a commodity, and these all are animals inside civil laws in Europe, if I only speak about Europe. And there, of course, and then there are legal personhood, the subjects that are only for human beings, only for us, for humans, and of course also in the world that we are living now, also corporations have these legal rights, and that's it. The law is very, it's not elastic, it's not pragmatic, it's already from the Roman law that we have. So the thing is that what we need to do is to give animals some rights, maybe simple rights. That will be a first step. Then fundamental rights, maybe written in some conventions. As I said, Europe is almost for free, for example. Recently, we were also with Markin at Max Planck Institute for Comparative Law in Hamburg, and we were talking about how to get access for animals, in which way, or is it in international law or in some other ways, and this would be very, very important because we could then protect the interests of animals also in the court. So it's a lot to say. I cannot say everything right now. Maybe later we can talk a bit if you want. But things, I think, they are slowly moving, very slowly, but are moving. There are a lot of young people that are enthusiastic also in the law field. They don't see this binary object, subjects, and that's it, because we don't live in Roman times anymore. And people should, I think, really stand for animals. And I really personally think that the world has to become vegan, or there is no world anymore. That's really my personal opinion in order to achieve, because the most terrible thing is for farmed animals. I cannot see where in the law they could have any rights, because people are eating them. So I think it's the most that we can do. It's really not eating them, because here I don't think how law can change. That's my personal view.
Thanks a lot.
Thank you.